Welcome to the webinar presented by the Office of Court Administration, or OCA, on the Municipal Court Judicial Council Monthly Court Activity Reports. My name is Sandra Mabbitt, and I am the Judicial Information Analyst at OCA, where our mission is to provide resources and information for the efficient administration of the judicial branch of Texas. First, I'd like to give you an idea of what the Judicial Information section at OCA does. Our section is responsible for working with the courts in collecting, analyzing, and publishing the court activity statistics from the reports submitted by your court and a total of over 2,600 courts in the state. We also publish and maintain the Texas Judicial System Directory using the information gathered from each of the individual courts. In addition, we are here to provide assistance to various court staff, as well as the court's case management vendors and local information technology staff on report guidelines and submissions. Now, today's topics are going to include some background information on the reports. I will also go over reporting, covering subjects such as the reporting requirements, and also going over some important case category definitions. I'll also discuss the actual submission of the reports, as well as the importance of reviewing the report both before and after submission. Then I'll provide you with some resources that are available to you. So let's get started with some background information. In regards to who decides what data will be collected on the monthly report, it is the Judicial Council that is the policy-making body for the judicial branch. The Council consists of 22 judicial, legislative, and citizen members. OCA collects the statistics from the monthly reports on behalf of the Judicial Council. Since it was created in 1929, one of the primary duties of the Council has been to gather statistics from judges and other court officials. Assisted by OCA, they are the only entity that collects comprehensive statistics on the operation of the Texas courts. So while many of you may refer to the report as the OCA report, it is actually the Judicial Council Monthly Court Activity Report. Now we'll review one of the principal reasons that you do the report each month, which is because it is required by law. Section 71.035B of the Texas Government Code requires each judge or clerk to report information as required by the Texas Judicial Council. Though we know that in the overwhelming majority of cases it is the clerk of the court that is submitting the report, ultimately it is the judge's responsibility that the court is submitted and that it is a true and accurate reflection of the court's activities in a given month. Sections 171.1 and 2 of the Texas Administrative Code is where you'll find the requirement that the report be filed no later than 20 days following the end of the month reported. So, for example, the report for July's activity is due by August 20th. Now, there may be times when you won't be able to submit the report by the 20th and may be a day or two or even a week late. That is fine, and there is no need to contact our office. But if you are going to go several weeks or months without being able to report, please contact us to let us know. Another legal requirement is found in Section 71.0352 of the Texas Government Code, which outlines some requirements in regards to juveniles for failure to attend school, parent contributing to non-attendance, violation of a local daytime curfew, as well as in instances where a child fails to obey a court order that would constitute contempt of court. There is a requirement to report the number of instances where the child was referred to juvenile court for delinquent conduct, and when they are held in contempt, fined, or denied driving privileges. Now I'd like to talk about what the report covers, specifically the scope of the information that is reported. Like any other reporting or measurement system, the report cannot possibly capture everything that you do as a court. Despite all the work that the clerks of a court do, the report is designed to reflect the workload of the judge, who, as previously mentioned, is ultimately responsible for the court's operations. And like other case activity statistics in the state, other states, and nationally, the report captures information on the court's inputs, that is, cases filed, and outputs, for example, dispositions or warrants issued. but not all the steps in between or even after a case has a final adjudication. It includes information needed by the legislative, executive, and judicial branches of our state government to make decisions regarding the jurisdiction, structure, and needs of the court system. Now that we've reviewed why you submit the report and what you report, I want to talk a little bit about how the report is used. One of the primary purposes of case activity data collection is to obtain a measure of the workload of the courts. Data on the nature, scope, and volume of work before the courts can be used as a management and planning tool to objectively assess how many judges, court support staff, and other resources are needed to process the court's work effectively and efficiently. It can highlight trends in case activity and allows for analysis of those trends. And it can also show how well the courts are fulfilling their functions. The data also allows policymakers to recognize an emerging problem, develop solutions to address it, and evaluate whether the solutions are working. Significant changes in the court's workload reflected in the report submitted were a significant reason the report was revised effective September 1st, 2011. And one of the most important things to keep in mind is that the statistics are available to anyone, not just the courts. Now let's move on to the reporting requirements and other information on submitting the reports. Our Reporting to OCA webpage has information that is very helpful for preparing and completing the report. At the top of the Texas Judicial Branch webpage, www.txcourts.gov, select Judicial Data, then Reporting to OCA. On the Reporting to OCA page, select the Judicial Council Trial Court Activity Reports. I would recommend that you bookmark the Justice and Municipal Court Monthly Reports webpage and save it as a favorite so that you can check back for updates on a regular basis. The page contains information helpful for preparing and completing the report. You'll find the form, instructions, and answers to frequently asked questions, other resources such as a flowchart for active and inactive pending criminal cases, and a spreadsheet with DPS violation codes classified by OCA case category to assist you in determining where cases should be reported. For your case management system vendor and IT staff, there are XML specifications and an XML tester that they can use to develop the capability for you to upload your monthly reports to the reporting database. This eliminates the need for you to type the data into the reporting database. If I could suggest the one thing you should periodically check for updates on, it would be the instructions for the reports. The instructions outline every line and every category on the report and are meant to be a tool that you can turn to if you have a question on what should be reported and where. When we make an update to enhance or expand an explanation, as shown on the screen, we will highlight any of those changes so that you can easily identify them. Now let's move from the web page to some reporting requirements. First, always remember that as long as there is a court in your city, you must submit the report each month, even if there is no activity to report. An example of this could be where a smaller city no longer has an officer writing tickets and all cases have worked their way through the court. Unless or until the court is abolished, the report must be submitted each month. Another requirement is that you keep copies of the reports that are run from your case management system for a minimum of 2 years. Don't confuse that with making a copy of the report from our website once you have submitted it. Also, if you manually prepare the report because you don't have a case management system, make sure you keep the report and any backup information to support what you submitted on the report in our website. As far as the actual report is concerned, the criminal, juvenile, and additional court activity sections must be submitted each month, again, even if the court had no activity. The civil administrative section was added in the last revision of the form in September of 2011 and must be submitted every month if the court hears civil or administrative cases. I would strongly suggest that you submit the civil section each month, even if you don't have any activity. If you upload an XML file, it most likely will be included. One reporting requirement is that a criminal or civil case is only reported once. However, there is an exception to that rule. That occurs when you report a case in the juvenile section in one of the first 9 case categories or under parent contributing to non-attendance, which is line 16. For those cases, you will also report a new case filed under the appropriate case category in the criminal section. So let's take a look at the juvenile section line items that I am referring to. This screen represents lines 1 through 9 and 16 on the juvenile section. Remember that this is the only time when a case will be reported twice. Now I'll go over some definitions, the first being pending cases. The definition of a pending case is a case filed that does not have a final judgment. A final adjudication has not been made. Only the criminal and civil sections have pending case balances that carry forward from the end of one month to the beginning of the next month. The juvenile and additional activity sections do not. Pending cases are separated between active cases and inactive cases. In other words, the total of the pending cases is the sum of acting plus inactive cases. So let's go over the difference between an active case and an inactive case. Active cases are those cases awaiting a judgment that the court is able to move to disposition. In other words, there is nothing keeping the court from moving the case to a final judgment. Again, this applies to both criminal and civil cases. In regards to inactive cases, first we'll go over some examples of inactive pending criminal cases that the court is unable to move to disposition. Examples are where an arrest warrant has been issued. Also, any of those cases that the court reports to Omni, to scofflaw program, or to a collections agency for failure to appear. Some additional examples include when a defendant is being held elsewhere on state or federal charges. If someone is incarcerated elsewhere, you cannot bring them to your court to satisfy any charges. It will also include cases where there is a question of mental illness or intellectual or developmental disability, also known as mental retardation, or while a defendant undergoes temporary or extended inpatient mental health treatment, the case would be stayed and therefore inactive. And then any other cases where the defendant is otherwise unavailable for adjudication. I would also like to bring up an example of cases that many courts have incorrectly thought were inactive, and that is cases in which a capias pro fine is issued. If we go back to the original definition of a pending case, which includes inactive cases, the case does not have a final judgment. Therefore, capias pro fine should not be included in the inactive case total, as a judgment has been entered in the case and was reported as disposed of on the report when the final judgment was entered. Now, if a motion for a new trial is granted or the case is remanded after an appeal, then you would apply the criteria outlined to determine if the case should be shown as active or inactive. Now, we do want you to report capias pro fines, just not in the criminal section as a pending inactive case. They should be reported in the additional activity section on line 3. Now let's review some examples of when a pending civil case could be considered inactive. This would include, but is not limited to, cases ordered to arbitration, cases when a notice or suggestion of bankruptcy is filed, those cases that are delayed due to the Soldiers and Sailors Civil Relief Act, when there is a suggestion of death filed in the case, then they may be considered inactive, and all other cases ordered abated by the judge. Now the next definition I will cover are cases reactivated. Report a case as reactivated when the following has been met. First, the case is currently reported as inactive, and further court proceedings and activities can now be resumed because the situation that was present causing the case to be considered inactive is no longer a factor. Now a final judgment may be entered in the case. Always remember that a case that has been reported as an inactive pending case must be reported as reactivated prior to it being reported as disposed of on the report. To help you in determining what status to report a case as, active, inactive, or reactivated, I would suggest that you refer to and print out the flowchart on the next page. Now that I have defined what the pending cases are comprised of, I want to give you some more information to remember. As we previously discussed, the criminal and civil pending cases are forwarded from the end of the month to the beginning of the next month, and theoretically should be the same. However, there may be instances where they do not match for various reasons, such as cases were not processed or updated in your case management system prior to the last month's report being run, or corrections were made to cases that had been reported in previous months. To account for those differences where the cases pending are not equal, a docket adjustment must be entered to account for that difference. Keep in mind that docket adjustments are meant to account for minor fluctuations in the pending cases. At times, larger adjustments may be necessary, and we will discuss those a little bit later. As shown in the examples on the screen, you will not find the docket adjustment line on the form. It is only found in the online reporting system. So let's talk a little more about what causes docket adjustments to help you avoid these in the future. Docket adjustments to increase balances are usually caused by new cases not being entered prior to a report being run, while those made to decrease balances are usually caused by dispositions not entered prior to a report being run. You may be able to avoid docket adjustments for these reasons. Remembering that the report is not due until the 20th of the month, one way to avoid them may be to set a day of the month, perhaps the 10th or the 15th, when all cases must be updated in your case management software system, and then run the report after that set time frame. While this won't guarantee that you will never have a docket adjustment, it should assist in greatly reducing the need to make them. When there are large docket adjustments made in the criminal or civil sections, they must be accounted for in the notes section at the bottom of the report. There are common reasons why you may need to make these type of docket adjustments, with the most typical being when an audit or validation or manual hand count of your cases is done, when you convert to a new case management system, when a judgment was entered in the case but the case management system was not properly updated to reflect the disposition. When this is discovered, you should enter the proper past disposition date, which will then result in a docket adjustment, or when you purge cases where the statute of limitations has expired. To make the docket adjustments, there are simple rules to follow. To increase the number of pending cases, simply enter that number you wish to increase the category by. Do not use the plus sign. And to decrease the number of pending cases, use the minus sign and enter the number you wish to decrease the category by. Continuing with some guidelines for docket adjustments, you should never enter the numbers that you want the pending cases to be in the docket adjustment line. If you do this, you will essentially double the number of cases that you report as pending, because it will be added to the number of cases pending that you brought forward from the end of the previous month. The next few screens will illustrate an example of this. In the example shown, note that it appears that in the traffic misdemeanors non-parking category, the court wished to increase the number of pending cases, while in the traffic misdemeanors, parking, and city ordinance categories, the court wanted to decrease the number of pending cases. However, by placing the numbers they wanted the pending cases to be, rather than those they wished to decrease or increase by, they virtually doubled their pending cases in those categories. Now let's take a look at the correct way to make the docket adjustments. You can now see that in the traffic misdemeanors non-parking category, the number needed to increase the pending cases by was entered, while in the traffic misdemeanors, parking, and city ordinance categories, the number to decrease the number of pending cases by, along with the minus sign, was entered. This is also an example of the type of large docket adjustment that would require an explanation to be entered in the notes section, and that would be for the traffic misdemeanors non-parking category. When you make the docket adjustments, you should review the active and inactive case line numbers. The number that you increase or decrease by will also automatically increase or decrease the number of active cases. If adjustments are needed, you will make the necessary changes to the inactive pending cases, which will in turn change the active pending cases so that they automatically total the total pending cases. The last area of definitions is dispositions. For the purposes of the report, the disposition reports the final outcome of the adjudication. For instance, convictions, acquittals, dismissals, dismissals after completing a driver's safety course, or a deferral. You will report the disposition when the judge signs the final judgment or a sentence is otherwise imposed. The date of the disposition will be the date that the judgment was signed by the judge, with whatever month the judgment was signed in being the month the disposition will show on the report. Also remember that you will report only one disposition, the final judgment, per case. Now I'd like to point out something that is commonly misunderstood regarding dispositions, and that is that reporting a case as disposed on the report does not necessarily mean that the defendant has satisfied all obligations in the case, such as the fines, fees, court costs, community service, etc. A conviction is a conviction, whether or not the defendant pays the fine, therefore should be reported as a disposition regardless if there are any outstanding obligations. Now, in the case of compliance dismissals, the disposition is not reported until the defendant provides proof of compliance and satisfies any requirements of the compliance dismissal. So, for instance, when the defendant is allowed to take a driver's safety course, they must provide the proof that they successfully took the course, or if granted a deferred disposition, they must satisfy all the terms of the deferral. To recap, so far we've covered the reporting requirements, the required reporting web page, so you now know where to find the forms and the tools to complete the reports, as well as some definitions relevant to the report. Now let's talk more about the database that contains the report in the actual submission of the reports. This screen shows the Court Activity and Reporting Directory System, or CARD, along with the link to get there. Here a variety of things can be accomplished. Remembering that I mentioned earlier in the presentation that the reports are available to the public, here is where both the courts and the public can access any submitted report with the most up-to-date data. This is because as soon as a court submits a report, it is immediately available. There is no login required to access these reports. This is also where the court will log in to submit the monthly reports either electronically via an XML file or by manually entering the data. Before we get into the actual submission of the report, I need to point out that the vendor and your local IT staff creates the codes that are used in your case management system to track the information that populates on the report. OCA does not create, specify, or have knowledge of codes or any other content regarding the case management system. It is the vendor or local IT staff's responsibility to complete all programming of the system, as well as all of the programming necessary to produce the reports. while OCA provides the XML specifications for use in setting up the files so that the court may submit the report electronically. Again, it is their responsibility to actually set it up for your court to be able to do so. So please refer any questions and discuss any issues regarding those systems with your local IT staff or vendor. In regards to submitting the report, all courts are required to submit the report online unless a waiver has been received from our office. To clarify, a waiver for good cause may be granted from reporting online. There is no authority to grant a waiver to a court giving permission not to actually complete the report. If you wish to be considered for a waiver in order to send the report to OCA for data entry, please contact our office. And if you are not already reporting online, you may contact our service desk by phone or email, and they will provide you with all of the information that you need. To submit the report online, each court will use a unique 9-digit login ID and password. Note that each court has only one login ID. We're all used to being told don't share your passwords, but that's not the case with submitting these reports. The login ID belongs to the court, not an individual. So if more than one person in your court will share the responsibility of submitting the report, you will share the login and password. Once logged in, you will come to this screen, which we call the court's main page. You'll see the name of the court as well as the current address we have on file in the Texas Judicial System directory. On the court's main page, all of the reports for each month and each section that have been submitted for the current fiscal year will be displayed. Remember that the state fiscal year begins on September 1st and ends on August 31st. Any section that contains errors will display on that page in red. Now on October 1st of each year, which is when you will be submitting the September report for the newest fiscal year, the court's main page will reset. So all of the reports for the prior fiscal year will no longer display. Once the September report is successfully submitted, that will display, and then each month after will display once they have successfully been submitted. The various functions available on the court's main page are Add New Monthly Report. Click on this to manually enter the report. View Electronic Submission. Click here to upload a report. That's your XML file. Search and edit new data. Click here to view and also edit the reports that have been submitted by your court from September 2011 and later. Run report new data. Click here to run various reports that have been submitted by a municipal or JP court from September 2011 and later, or for a county or district court from September 2010 and later. Run report old data. Click here if you wish to run a report stored from our old database for the period September 1992 through August 2011 for municipal or JP courts, or through August 2010 for county or district courts. Note that these old data reports may not be edited. For additional information on running reports, please refer to the separate webinar on that subject. Now let's go over the options for submitting the reports, the first being manually entering the report. To do that, click on Add New Monthly Report. A tip when entering the report manually is to only enter a number where you have activity to report. In other words, it is not necessary to type a 0 in any field where there is no activity to report. Once you have completed the necessary information and click on Submit, the system will automatically fill in zeros where there is nothing reported. So keep this in mind if you have no activity to report in any or all sections. Because the number of pending cases gets carried over from month to month, reports must now be entered in sequential order by month. There are two ways that you can tell if a report has not been entered for a previous month. The first and easiest is by checking your court's main page to see if all the previous month reports are there and are complete. Another clue would be if you open up a screen to start entering a report and the number of cases pending at the beginning of the month is blank. We've covered entering a report manually. Now let's go over uploading a report. As a reminder, your vendor or local IT staff will need to set this up using the specifications found on our website and also validate the XML file format. You will also find on the Justice and Municipal Court Monthly Report webpage some frequently asked questions regarding the online report submission and XML file submission. You should refer to that document if you have questions about the process or if you receive an error message when you attempt to submit the report. Note that the XML file must be formatted properly to successfully upload to our database. In addition, some vendors have informed courts that it is required that once the report has been submitted, you must go to the bottom of each section and click on Submit. This is not correct. The upload submits each section. So here we go. We're ready to upload the report. So you'll click on View Electronic Submission. Here you will click on Browse to find the file you will upload and then click on Submit. Once accepted, you will automatically be taken to the criminal section. At this point, this is where you can start verifying the report section by section, using the copy of your report that you printed out and comparing it to what was uploaded. Now, if you've got to the point where you browse to find the file and you do not know where it was stored once you saved it from your case management software, you will need to contact your vendor or local IT staff for assistance. Just like when you are manually entering the reports, you must submit the reports in chronological order, oldest outstanding month first. If you attempt to upload a report and the previous month has not been submitted, you will receive the error message shown on the screen. Now, a successful submission of a report is obvious when you are entering the report manually because the section you are submitting will generate an out-of-balance message immediately if there are issues with the report. However, if you are uploading an XML file, you need to take a look at your reports by section after you load them to make sure that everything is in balance. We find that many reports submitted in this manner are out of balance because the docket adjustments have not been entered or because the file has not been properly formatted to add the lines that are the sum of other lines correctly. We also strongly suggest that you print out a copy of the report from your case management system. Remember the one that you need to keep for a minimum of 2 years and compare it to what was loaded into the database. Unfortunately, there have been instances where the two do not match. If there are discrepancies, you will need to address those with your vendor or local IT staff. As previously mentioned, if the XML file is not properly formatted or if it is missing critical information, it will not upload and an error message will be received. You will need to contact your vendor or local IT staff to correct the file before you can successfully upload the report. So now that you're at the point where you have successfully submitted the report, let's discuss some information you need to know. We already talked a little bit about documenting large docket adjustments in the notes section, but that isn't the only time that you should document something. Some other examples would be when you have a large number of dismissals when the prosecutor clears old cases from the docket. Also, whenever there is a higher or lower number of cases reported due to unusual or infrequent circumstances. An example might be for a smaller court when there is no longer a police officer writing tickets. Another might be when there is a warrant roundup or amnesty program, or during spring break when there is a larger number of violations than usual. Simply make a note to document the circumstances. It doesn't need to be an elaborate explanation. Rather, it should be enough information to explain the circumstance. That way, in the event an audit is conducted in the court or we are reviewing the reports in our office and the unusual activity is seen, the reason why is documented. Now, what we don't want you to note here are a change related to the Texas Judicial System directory. For instance, a change of the judge, address, phone number, etc. At the end of the presentation, you'll find various ways that you can inform us of these changes. In the Prepared By area, which is right below the Notes section and directly above the Submit button, please put the full name of the person OCA can contact should there be any questions on the information in the report and we need to talk to someone about it. Now for some more hints. When you've finished manually entering a report and submit it, make sure that you receive this message. This will let you know that the report was saved successfully and that there were no errors detected. I will show you in a moment what will occur when there are errors in the report. And as previously mentioned, if filing the report by uploading an XML file, you do not need to click on Submit in each of the sections. I can't encourage you enough on the importance of reviewing the report not only for accuracy, but also to check for any reports that are out of balance. If data does not comply with the rules, the report is marked in red on the court's main page and gets flagged as out of balance in that section. Things such as total lines not adding up correctly or a negative number in any line other than the docket adjustment line will cause that section to be out of balance. When a report is out of balance, the report will show the specific fields that are not adding up properly so that you can make the corrections. While the report will show you where there are errors, there may be additional lines that will need correction. In this case, the negative balances brought forward from the end of the previous month were caused by more cases being disposed than the total cases on the docket. So the total number of cases would need to be verified as well as the total dispositions to balance the report. The report will show the specific fields that are not adding up properly so that you can make the corrections. If you submit those corrections and there are additional or new issues, the report will again show you where those errors are. When reports are out of balance, you should correct them before submitting any subsequent months. In this example, the criminal section is out of balance in several months. Corrections should be made the same way the reports were originally submitted, oldest month first, working forward. Note that even if you correct the oldest month and the reports are automatically put in balance, each month should be reviewed for accuracy. That is because you may have made docket adjustments or other changes based on a previous month being out of balance. So now that you understand why you do the report, you know where to find the tools to assist you in completing the reports, and you have the knowledge needed to submit the report, let's recap and talk a little more in depth about reviewing the report. Now I know I've mentioned it several times, but you should review the report submitted each month, comparing it to a copy of the report from your case management system. This should be done even if your report is not out of balance. So let's go over some things you should look for. Check for reports that are marked in red indicating that they are out of balance and correct before submitting any further reports. Review the report to check for filings, docket adjustments, dispositions, or pending case numbers that are too low, too high, or just don't make sense. If you are submitting the report manually, a typographical error could have been made or numbers could have been placed into the wrong line. If you uploaded the report, a recent update to your case management system could have caused an issue with your report to no fault of your own. Another common issue we find with courts that upload the report is that the report only contains the pending balances in the criminal and civil sections, and the rest of the report is all zeros. If you are not intending to report no activity, this is a problem that should be discussed with your vendor or local IT staff. You need to look for docket adjustments and determine if they are correct, and if so, is an explanation needed. Another area we have seen common issues with is the reporting of uncontested dispositions versus trials. Generally, the number of trials should most likely be much lower than the number of uncontested dispositions. Those cases where the individual does not go before the judge but rather pleads guilty and either pays the ticket in full or sets up a payment plan. For the compliance dismissals, are there none reported when you know there should be, or are they obviously too low or too high? The bottom line is that while we know it is difficult for you to know the exact number that should be reported on any particular line, you should be able to determine if the numbers are inflated, too low, or missing altogether. Look for instances where there are negative pending cases. These reports will also be out of balance. Remember that the only place where you can place a negative number on the report is in the docket adjustment line. Look for those reports that you upload and the report from your case management system doesn't match what was submitted, or it shows all zeros except for the pending cases line, and make sure you contact your vendor or local IT staff to get it corrected. Errors in lines involving dollar amounts are another common issue. Some of the lines we found that to be true are cases satisfied by community service, satisfied by jail credit, and where amounts were waived for indigencies. These lines should contain the number of cases, not a dollar amount. Another area where we discovered a widespread problem in reporting was in the All Other Disposition line. This category should rarely be used as there is a broad choice of dispositions to choose from, yet hundreds and sometimes thousands of cases were being reported there. Examples of what you would report there are transfers to juvenile court, either mandatory or discretionary, or probationary or compliance dismissals that do not fit into one of the other disposition categories. If you are unsure, please feel free to contact us. Look for instances where cases had been incorrectly reported under all other dispositions. One example was where vendors had the software automatically set so that if a disposition code was entered but no judgment date, or vice versa, it would populate on the All Other Disposition line. Another was in the dismissals of old cases, those where the court is attempting to clear the docket of old cases that will not be pursued. These cases should be reported as dispositions prior to court appearance or trial, disposition by prosecution. One more example was when cases should be reported as an uncontested disposition when a payment plan was set up. If the court costs, fines, and fees were paid in full, they were reported on the correct line. But if the defendant set up a payment plan, they were reported on the All Other Disposition line. Now, I've mentioned it a few times before, but it warrants repeating. Check for docket adjustments that are larger than the acceptable minor fluctuations in the pending cases and place an explanation in the notes section. Review the reports for the ratio of uncontested dispositions to trials. Generally, the trials will be a much lower number, but we have found instances where, because of a coding issue in the software, all the dispositions are reported as trials when they should be reported as uncontested dispositions. Also check if compliance dismissals are obviously too low or too high or missing altogether. Now let's finish up with the things to look for when reviewing the report. While doing the overall review, check the ratio of filings to dispositions. Also review the juvenile section if you have activity to ensure that it's present. And review the additional court activity section. Many times we find that the only thing reported is the revenue, but the court should be reporting magistrate warnings, arrest warrants, or other activity present in that section. Also, remember that community service and jail credit are only reported once the case is satisfied in full. To make sure you have a clear understanding of what should be reported, refer to the instructions on the monthly reports webpage. Make sure you keep an open dialogue with your software vendor and contact them when there are obvious programming issues. Remember, they are the only ones who can correct them. And I also encourage you to contact our office if you have any questions or if you need our assistance. So now that you have submitted and reviewed your reports, I want to go over what happens with the information. I mentioned earlier that the Judicial Information section publishes an annual report each year containing the court-reported information of over 2,600 courts. Prior to publishing that information, we want to provide the courts with an opportunity for a final review to make any corrections necessary. In October, we send a letter to the court with a copy of the report, combining all months submitted, and ask that the information be reviewed and corrected if necessary. Keep in mind that if you find that corrections are necessary, you must make those corrections to individual months, as corrections to the year as a whole cannot be made. So now I'd like to go over how you will make the corrections to the reports. Regardless of how the report was originally submitted, corrections may be made either by uploading a new XML file or by manually changing the numbers. And as just discussed a moment ago, remember that you must make the corrections to each month. There is no way to make changes to a combination of months. So let's say that you discover that no driver safety course dispositions had been reported for an entire year. You must correct each individual month rather than entering all the dispositions in one month simply to make the total for the year correct. Remember that the report is to be an accurate accounting of the court's activity for a particular month. Make sure that you are making the correction sequentially to the oldest month first and work forward. Even though only the criminal and civil sections carry pending balances and are the reason you should do so, I would suggest that even if the corrections needed are in the juvenile or additional activity section, that you make them sequentially. And also remember that especially when you upload a new XML file, the report should be reviewed in its entirety just like when it was originally submitted. Also remember to review any subsequent months. While you may think you don't need to if it's only 1 or 2 months that needed to be corrected, you may have entered docket adjustments or have other things that will need to be verified. One common reason this is so important is because when docket adjustments were entered in a month because of a section or sections being skipped, once the missing sections are submitted, corrections will need to be made to those subsequent months already entered. Not doing so could trigger a similar situation we discussed earlier. That being when you enter the number of cases in the docket adjustment line that you want a total to be rather than adjusting up or down by the difference. The result would be a doubling to the pending numbers. Now here is a screenshot of an instance where the criminal, civil, and juvenile sections were not submitted in the month of October, and the civil section was also not submitted in the month of November. Instead of entering the missing criminal section prior to submitting the November report, the November report was submitted and docket adjustments were entered to account for the missing pending cases. Once the October report is submitted, the docket adjustments will need to be removed from the November report, and the report will need to be reviewed in its entirety to ensure everything is correct. Now we're to the end of the presentation, and I'd like to give you some resources that I think you will find helpful. By this point in the presentation, you've become very familiar with the CARB webpage. You should bookmark this page so that you can find it easily rather than having to navigate through the Judicial Branch website. Just as a reminder, this is where anyone can run reports, while this is also where the courts log in to submit the reports. You can also access the Texas Judicial System directory, both the published directory, which is done annually to take a snapshot of the judiciary, as well as the live directory, which provides the most up-to-date information. You've also become familiar with the Monthly Reports webpage. You should also bookmark this page and check for revisions periodically, especially to the instructions. The Texas Judicial System Annual Report webpage contains fiscal year summaries of court activity data and analysis of trends. The Publications webpage contains information on filing fees and court costs. And on the Municipal Courts Training webpage, you'll find a variety of resources where they also offer information on programs and training events. We are now at the end of the webinar, and I wanted to make sure that if you have any questions, you have our contact information in Judicial Information. The first email address shown on the screen is one that we all monitor, and the first one of us that sees an email will answer you. You may submit questions to that email address as well as any updated directory information. The main number for OCA is listed, as well as a fax number that comes directly to Judicial Information. Then you will find each of the staff's individual contact information. Please feel free to contact us with your questions or concerns at any time. Thank you for taking the time to view this webinar. I hope that you will find it helpful in the completion of the monthly activity reports.